So we're actually within our next installment of HART Fertility Diaries, and today we're chatting to Andrew Martin, who is the owner and director of Fertility Law, which is a boutique legal consultancy firm that specializes in the law relating to assisted reproductive treatments, which is ART, and artificial reproductive treatments for people wishing to start or expand their family. So Andrew, thank you again. If you wouldn't mind just telling the viewers a little bit more about yourself and how you came to establish your law practice.
Cool, pleasure. Morning, thanks Angela, thanks for having me. Thanks to the HART team for putting this together. Always enjoy being a part of these talks. Okay, so for those of you that don't know me, my name is Andrew Martin. I'm the Director of Fertility Law, an attorney based in Cape Town, but I practice nationally throughout South Africa. I've been in the industry about 11 years now, having gone through IVF and surrogacy myself with my wife. Also a recipient of an ART baby. My little boy is almost 3 years old now. He's brought a definite light to our lives. So a couple of years ago, I was in a commercial litigation firm, kind of headed up the home loan foreclosure department, absolutely hated taking people's homes away, and on the same hand, dabbled in fertility related work and really enjoyed assisting people in getting children, creating children, fulfilling lifelong dreams. And one day I sat down with my wife and my family and we decided, look, we're going to take the jump and start a boutique practice and leave being that nasty type of attorney in the past and becoming the nice type of attorney that helps people. So a little over 3.5 years ago, I left and opened up the practice, and it's gone from strength to strength, which is I'm truly blessed that it has. It's a complete passion project. I always say to my wife that I considered my desk 24 hours a day. If I had 24 hours a day to sit at my desk, I just love getting pictures and emails about, I don't know, I call them my nephews and nieces when they're born, and my godchildren. So, like last week I got pictures of twins that were born, and pictures of a little boy that was born through surrogacy, and it kind of makes me realize why we do this job.
No, absolutely.
So that's me. Yeah.
Perfect. So let's start with the questions. We've got a lot of questions to get through, a lot of interest in today's interview, so it's going to be fun for you answering them all.
Perfect.
Okay, let's get started with the gamete donor consent forms. Why are these important?
So in general, medical consent forms are incredibly important from an informed consent perspective. Medical practitioners are required to obtain the informed consent of their patients. So it's very important that clinics get consent forms signed in the first instance, and properly legally drafted consent forms at that. But in the instance of gamete donor consent forms, it's even more important because our legislation, specifically the regulations to the National Health Act called Artificial Fertilization of Persons Regulations, require very specific information to be recorded by the authorized institution, being the fertility clinic, and the competent person, being the fertility specialist. So it's very important that these documents are signed, filled out correctly, and kept on file for time immemorial at present.
Okay. So is known donation allowed in South Africa?
So South Africa is an interesting jurisdiction. Predominantly our gamete and embryo donation is done on an anonymous basis. There is talk of opening up donation to make it a completely known donation kind of environment, which I am opposed to because I think it will kill our donation industry. And our regulations specifically prohibit the identity of donors being made available. So if you were to approach a fertility clinic or a donor agency to be a donor, your identity would be anonymous predominantly. And I know we're going to touch on these issues as we go through this. But that being said, our regulations do allow for known donation. And these scenarios are predominantly where friends are helping out and or family members. So yes, our law does allow for known donation, and a known donation being that the recipient and the donor are known to each other.
Okay.
Another aspect that known implies is the identity of the donor known to the child, and potentially we'll answer that later on in the questions.
Yeah.
But for now, known donation being recipient and donor know each other.
Okay. And that's where an agreement is also extremely important, right? Especially with known donors.
Yeah. So, look, there's been a lot of interest in known donation in the news over the last couple of weeks with the application in the Pretoria High Court where a known donor is applying for parental rights and responsibilities where he donated to a same-sex female couple. I'm also aware of another one which is currently pending in the Johannesburg High Court, and I've actually been chatting with the dad, a similar scenario. So to answer your question, yes, it's very important for the donor consent forms to be signed at the clinic because they record it on a clinical level, but also for the parties to have some kind of record between the two of them that it is a known donation. And over the years, this concept of a known gamete donation agreement has evolved, although our law doesn't specify the actual name of it, but we call it a known gamete donation, and it regulates and confirms parental rights and responsibilities of the parties and confirms that the donor is a gamete donor for the purposes of artificially fertilizing a recipient. So yes, very important. Without it, it's very hard to show intention or proof of intention, which is ultimately the query that the court would ask in time.
Yeah, of course. How does gamete and embryo donation work in South Africa or generally, actually?
So predominantly, I said, it's predominantly done on an anonymous basis. So let's use me as an example. I want to be a sperm donor. Who do I go to? I would then either look up sperm donation in South Africa, or I'd look up a fertility clinic and I'd contact the fertility clinic or the donor agency, and I'd say, look, I want to be a donor. They'd send me out they'd be great. So at this point, I'm now an anonymous donor. I'd have various tests, psychological and blood tests done, as well as some kind of genetic screenings done. And then I would provide very specific information to either the donor agency or the fertility clinic, who would then open up a donor file, and they would record both my identifiable information as well as very specific physical characteristics, etc., that are made available to the recipients. But only specific information is then made available to recipients. So my identity and any information that would make me identifiable is not given to the recipient. So they would then create a donor profile with, I don't know, some donor agencies use pictures of celebrities with whom I'd look like or something, or baby pictures or something like that. But predominantly there's no identifiable information provided. And then they would match with me, and I'd be given a very unique donor code. With that would be how I would be identified as the donor.
Okay, so there's absolutely no ways I can find out the identity of a donor.
So absolutely no ways is quite a strong description. The Act prohibits the competent person from providing that information without the court's authorization.
Okay.
So there is a door which is open to recipients to apply to court to try and find out the identity of the donor, but it's something we don't do at all, or very often at all. And I think the court would, without the donor's consent, refuse to provide that information to the recipient parents. So in South African law, in practice, we are seeing this evolution of different types of donors. One is an anonymous donor, one is a completely known donor on the far extremes, the two extremes, and then in the middle we have this idea of a identifiable donor. So a donor who starts off as anonymous with the consent or the intention that he or she is willing to potentially become known to the child at a later stage in their life, but that would require a court application in order to get this. So some legal jurisdictions like Australia have the identity of the donor is able to be accessed once the child reaches 18, and that's regulated by a central donor registry. But South Africa, we don't have that.
Yeah.
So no, your identity is yes, your identity is completely protected as a donor, but if you were to consent to having your identity made known, then we could go through a court process of kind of making you a known identified donor.
Okay, great. And this obviously leads on to the next question, where we ask, does the donor have any rights? So you mentioned that he could actually, not really.
So the donor doesn't have any rights.
Okay.
So an anonymous donor specifically doesn't have any rights. Our law is very clear on the rights of parents with regards to children born through artificial fertilization, and the rights of children born of artificial fertilization and the use of gamete donors. So specifically, Section 43 of our Children's Act says that no rights accrue to a gamete donor where they've donated their gametes for the purposes of artificially fertilizing a recipient. So once you become a donor, you don't get parental rights. The confusion in these known donor scenarios in Johannesburg and Pretoria is that, look, I think the circumstances of each case would need to be known, which I don't know, but South African law uses a standard of the best interest of the child in assessing whether, you know, certain rights could accrue to a child or be taken away from a parent or given to a parent. And in those circumstances, as far as I understand some of the facts, the donor, he kind of morphed from a donor to a parent and was identified as a parent, played a part in had contact, had care of, financially contributed. So those inquiries and circumstances would play a part. So potentially your donor could get rights if you were to change his kind of role in your child's life. But if he were to be completely out of your child's life, then no, your donor and your child doesn't have any responsibility or rights to the donor, or the donor doesn't have any rights to your child.
Okay. I actually saw you on the news regarding that case. So could you just give us a little bit more information about that? Because it goes on nicely from the question before.
Yeah. So all right. So South African parental rights and responsibilities is quite clear when it comes to heterosexual couples. So the birth mother, who's considered the biological mother, she doesn't necessarily need to be the genetic mother, but the biological mother automatically obtains parental rights and responsibilities. The biological father, who isn't necessarily the genetic father, because obviously one could use a sperm donor if you're married to your wife as a heterosexual couple, but the biological father automatically obtains parental rights and responsibilities if he's married to the mother at the time of the birth or was at the time of the conception. And then, or if he isn't, he obtains parental rights and responsibilities if certain circumstances happen. So he identifies with the child, he contributes financially, etc., then he automatically gets parental rights and responsibilities.
Okay.
A person can apply for contact, care, and guardianship in terms of our Children's Act. So an interested third-party person can apply to court for parental rights and responsibilities. So what happened in these cases is that the donor, supposedly according to the parents, was a donor and wasn't going to have any parental rights, but the circumstances were such that he had contact with, he had care of, financially contributed. So he now kind of morphs from a known donor into a biological father, for want of a better word, and the partner of a same-sex, in a same-sex relationship, mother, the two mothers, the non-biological, non-genetic mother, doesn't automatically get parental rights and responsibilities. So it's a very complicated, convoluted area of our law. There are proposed amendments to Section 43 of our Children's Act, in which the partner of a same-sex couple relationship will get parental rights automatically, but they're in the draft phase and comment phase, so they're not law yet. So I think the court in those instances is actually going to give the sperm donor rights and responsibilities. That would be my kind of opinion, because I think it's in the best interest of the child. He's already had contact with, he identifies, he knows the identity of his father, and all of a sudden you're going to take it away. But I'm sure they had expert evidence that might contradict that. So I don't know. I wasn't intimately involved in the arguing of the matter.
Okay. That was an interesting one, though. I just wanted to ask, can my donor claim any parental rights at a later stage? We discussed that.
No, so that's unless you change the circumstances of your Yeah, unless you change the circumstances of your known donor, no, he can't. He or she can't.
Okay. What is the donor data bank?
So, this being South Africa, we've made provisions since 2011 for a central donor data bank run by the Department of Health, which will record the identity of every donor, together with record the number of live births that have been conceived, born as a result of each donor's donations. However, our central donor data bank is not in existence. SASRIG, the South African Society for Reproduction and Endocrinology, the governing body of all the fertility clinics, has started a voluntary donor data bank with the consent of the Department of Health, in which they are trying to record donor births, so that we don't, because each donor is limited to 6 live births. So at present, there's no communication on a great level between fertility clinics, so donors could bounce between fertility clinics and have 6 live births at each fertility clinic, and it could cause problems from a genetic point of view. So they've tried to start centralizing this information, and maybe in time our government will take it over, but I don't know about that. So the central donor data bank is supposedly there to record live births and for the government to keep the identity of the donor, but you as the recipient or child will never be able to access that identity of your donor, even from our central donor data bank.
Okay, that's interesting. So the next question that's come in: if I'm a fertility clinic, what should I do for gamete donation from a consent perspective?
Well, my advice would be to contact me for your consign option. No, I'm joking. But yes, if you want to have specific clinical consent forms that your donors who are coming in for treatment would sign, where they consent to be a donor, and where there's a specific and clear, concise recording that they are a gamete donor as per regulations in our Children's Act. So to specifically have treatment consents that relate to donors. Often clinics just have IVF consents or FET consents, etc. They don't have very specific consents. So my advice would be to make sure you have very treatment specific consents available.
Okay. And you draw those up? You would draw, or a lawyer would draw that up?
We offer a cloud-based repository or library of all clinical consent forms needed by clinics.
Right. So why would consent forms be necessary with an intrauterine insemination, which is IUI, if a sperm donor has to consent to remaining anonymous before and after the child is born? Long question.
So look, it's more a matter of getting informed consent from the donor and keeping a physical record of that consent that's been signed by the donor, so that should one need evidence of consent and intention consent and intention at a later stage, say for a court application, then that can be used as evidence to show what the intention was at the time.
Okay.
So I'm going to interrupt you. So this talks to a lot of home insemination issues that we have in South Africa, where couples...
Yes, I've heard about this.
Where couples get donor sperm from donor banks and they do home insemination. So technically, any form of artificial fertilization can only be done by a competent person or authorized institution. It's on a technical reading of our regulations, a criminal offense to do home insemination. Quite interesting that one doesn't really know that, but not that it's enforced, but technically it should only be done at an authorized institution.
Okay.
So I think what normally would happen is that I'd contact sperm bank, or I'd get a friend to donate, and he'd do his business, and we do a home insemination kit, and you're kind of in breach of the relevant regulations and provisions of our Children's Act and regulations, the National Health Act, which carry with it criminal sanctions. Not that you think you're going to get arrested for doing home insemination, but my point is that it's better to do it at a clinic with consents, where there's properly records of party's intention, because to do this thing at home on a handshake and a high five and a WhatsApp is going to cause trouble later on in life. And we've had many cases of donors coming to us saying, no, but that wasn't what we discussed at the table before we did the IUI or the home insemination. And
yes, I've read a lot about that actually. So what forms are necessary during an IVF treatment?
So from a normal IVF treatment consent perspective, you would get and I suppose we're talking in a donor scenario. So we do, using a sperm donor as an example, we would do a consent form for egg retrieval for IVF. So egg retrieval, fertilization using donor sperm. So it could be that I have got frozen eggs, or I want to freeze eggs initially, so I could just do a consent form for an egg retrieval and a cryopreservation. So there would be two separate consents, so egg retrieval, then a cryopreservation consent. Alternatively, I would do a fresh cycle, so I would do an egg retrieval and then I'd use donor sperm. That could be a third consent form, that's an option. Or I could do a frozen embryo transfer cycle where I've got either frozen embryos, or I'm going to thaw frozen sperm. So you're probably looking at about 4 or 5 different various options that are available from a consent perspective for IVF. But it really depends on the treatment type that you're doing.
Okay. And you would obviously advise our patients of that.
So my advice is that clinics have specific consents relating to specific scenarios. So, heterosexual couple doing IVF using donor sperm, it's one consent. Single mother doing IVF using donor sperm is a separate consent. Heterosexual couple using donor sperm, donor egg is another consent. Sometimes these things are all they've tried to kind of roll them into one consent, but my opinion is that it should be specific, because there are specific little changes that one would make to a consent form depending on the type of treatment that is available or that the patients are undergoing.
Yeah, that makes total sense. What is an embryo gamete disposition?
Oh, it's a question from left field. I like that. So this is my true passion project in South African fertility circles at present. Is a disposition is an agreement and or declaration which regulates what happens to your frozen material should one of life's unexpected events happen: death, divorce, incapacitation, separation, stopping of treatment, passing of time, etc., etc. Think of it like an antenuptial contract for your frozen sperm, eggs, and embryos. The problem with these at present, so let me back it up. So this is a kind of an advanced life directive which records your intention at the time of freezing them. Obviously, they can be updated and amended at any time while you're able to provide your consent, but should you not be able to provide your consent. So I'm in a car accident, I'm in a coma, I've been in a coma for 18 months. My wife and I have always spoken about having a sibling to our son. We've got embryos in storage. For her to carry a pregnancy, she would need my consent to implant the embryos, because I would automatically obtain parental rights and responsibilities. I obviously can't provide my consent because I'm in a coma. What do we do? If one were to have a disposition agreement in place, then we could look at what our intention or my intention was, and we could act in accordance with it. If, however, I don't have that, then my wife would be forced to approach the court to try and argue a case for the court to provide consent and authorization for her to use the gametes or the embryos. And often what we are finding now, and it's funny, COVID has kind of highlighted this at some clinics where people have passed away because of COVID, where they are not in a position to use frozen material, and they are now stuck without any kind of confirmation of intention, and it's causing, where you can spend 3,500 Rand potentially on a disposition versus hundreds of thousands of rands on a court application. I think you would do this disposition first. The problem is that often people are not in the headspace where they are thinking about what could go wrong in the future. They're always thinking about being positive now and having a baby. So they put off signing dispositions and put off planning for the bad in one's life, and often the bad happens very quickly and at an unexpected time, and it's too late.
Yeah.
So my goal is to get every client who freezes material, gametes, sperm, eggs, embryos, to sign one of these things at the time of freezing it. Yes, I know you have to have some very difficult conversations, but it's an easier conversation to have than to try and work out how to have a sibling without one.
Yeah. There was actually a case, quite a high profile case in showbiz recently, where it was an ex-husband. They had frozen embryos. And she had moved on, but they hadn't had anything signed. And it was a huge court battle between the two of them.
Exactly. So if they'd agreed up front, then they wouldn't have had a court battle.
Yeah, exactly. Okay, so we're moving on. What other forms do you advocate when somebody is starting a fertility journey? I know there are different aspects. We know that there are different forms. Maybe we can touch on surrogacy.
Well, yeah, so forms, okay, well, surrogacy requires very specific agreements to be in place and court orders to be in place prior to treatment occurring.
Okay.
So from an IVF perspective, heterosexual couples using their own material would just need to have the relevant clinical consent forms signed. If one were to use donor material, then one would either have a known donor agreement in place prior to starting treatment, and then obviously the clinical consent forms relating to treatment using donor sperm, eggs, or embryos. If one were to be doing surrogacy, then one would have a court order and surrogacy agreement, or surrogacy agreement which has been incorporated into a court order prior to starting treatment, and the doctors are specifically prohibited from doing any artificial fertilization without such authorization.
Okay.
So other than that, there aren't really any other forms that are legally required other than to sign one's consent. So
yeah. Okay, perfect. Thank you. And onto surrogacy, which is, I know, another passion of yours. What
Absolutely.
are the surrogacy laws and forms needed if I wanted to become a surrogate mother, for example?
Okay, so well, look, surrogacy is a whole nother hour and a half conversation that we can have, but surrogacy is regulated by our Chapter 19 of our Children's Act. We're very lucky in South Africa in that we have specific legislation that regulates surrogacy. Came into effect in April 2010. Prior to that, we used to enter into a surrogate mother agreement. The surrogate would get parental rights and responsibilities. She would get on the birth certificate, and then we'd go through a process of a known adoption through the children's court using a social worker. Uncertain, not ideal to adopt your own genetic material. Luckily now we've got provisions of our Children's Act which stipulate that we are required to go through the High Court for an order in which we confirm the surrogate mother agreement, we authorize the doctors to perform artificial fertilization, we confirm parental rights and responsibilities of the parties. So it allows and provides certainty to the parties for surrogacy before treatment is even started. So the forms that one would need to do is, look, we have to show the court that persons are suitable to both be commissioning parents and surrogate parents. So there's a clinical psychological evaluation which is done, criminal background check, police criminal background check, a medical screening which is done, and then we enter into a written surrogate motherhood agreement, and then that precedes a formal high court application process with various affidavits which are provided to the court. But one would then only be able to proceed with a surrogacy process or journey once one has a court order in place, and then that authorization for artificial fertilization is then valid for an 18-month period. So you've got 18 months within which to get pregnant. Should you be unable to get pregnant during the 18 months, we have been successfully able to extend that 18-month period for a further 18-month period. So you're not kind of solely limited. Some courts will ask for, a re-screening, re-psychological checks. Some do, some don't. So we kind of deal with it on a case-by-case basis. But ultimately, one is limited for 18 months within which to get pregnant.
Okay, perfect. And a question that's come in here is, will I need a consent form if I'm using my partner's sperm?
Will I need a consent form if I'm using my partner's sperm? You will definitely need your partner to provide his consent for the use of his sperm. You can't just steal it.
Well, there we go. Thanks for
so yes, the
clinic
clinic would then provide you with a consent form in which both of you consent to the use of his gametes. We wouldn't use the term donor in this scenario, although our regulations use the term donor. They've incorrectly used the word donor to also mean a partner or a spouse doing treatment with the recipient. So they need to differentiate between recipient and donor. Recipient and donor and recipient and husband, because they have completely different consequences. But yes, you would need your partner's consent.
Okay, perfect. Who has access to my signed consent forms?
The clinic and you, and anyone you give permission to. No one else.
Okay.
So we are protected with, protection of or access to information and PIA and POPI, protection of personal information. So your information is specifically personal and will not be able to be accessible by any other person other than the clinic who will be treating you, and then yourself. Okay,
perfect. And what sort of consent forms do egg donors need to sign? It's another one that's coming in.
So a donor would need, it depends. If a donor we're going through an agency, I would assume that the donor is signing some form of consent/agreement with the donor agency. The donor would then move on to the fertility clinic, who would then do the treatment or the egg retrieval of the egg donor, and then at that point, as the egg donor, you would then again sign a clinical consent. So ordinarily, you'd probably sign two kinds of forms.
Perfect. Do my eggs and embryos belong to me or to the clinic?
Good question. Right, so our regulations to our National Health Act are unfortunately very confusing and very badly worded, and are under proposed amendment at present. The proposed amendments take out the issue of ownership in total. However, and I'm going to give you the example of where it's a sperm donor and an egg donor. So if you're a sperm donor, if you are a sperm donor, your sperm is then owned by the competent person, authorized institution prior to artificial fertilization. After artificial fertilization, the embryo that is created is owned by the recipient. So the wife, the surrogate, if it's your surrogate, if you're a surrogacy. If you are an egg donor, technically your eggs should, in terms of the act, remain owned by yourself. So, and then after fertilization, they are then owned by the recipient. So once the embryos are created, the recipient owns the embryos. Sperm donors, it differentiates between egg and sperm donors. So sperm donors seem to lose their ownership and egg donors seem to retain their ownership. But in reality, and in terms of the clinical consent forms and the donor consent forms that are drafted, both egg and sperm donors would give up their ownership in their eggs and sperm to the respective clinic if they're donating to a donor bank, and then if they're donating to a specific recipient. So in my known donor agreements, I get my donors to retain ownership in their own genetic material, but to allow access to it by the recipient. So if I were to be an egg donor and I freeze 20 eggs, then I would retain ownership in my eggs, but I would authorize the recipients to access my frozen material in order to have X amount of, or agreed amount of children. So make 2, they can access it until they've had 2 live children. Thereafter, I retain ownership in my eggs.
Okay.
The embryos, once created, obviously then go and become owned by the recipients, but limited to the agreed number of children. So it's confusing, it's unnecessary, convoluted. It doesn't differentiate between, or does, but it doesn't, recipient, donor, husband, spouse. It's very confusing, and with the new regulations still going to disappear into nothing, and we're going to probably have to regulate these things through private contract.
Okay.
Which is going to make life interesting.
Yeah. For you. Is there any additional cost to consent forms? So if I'm, if I do decide no.
Oh, so okay. I don't see clinics charging you to sign consent forms.
Okay.
Obviously, a clinic will have to incur some kind of costs in order to create the consent forms.
Okay.
Access my system, but you as the recipient, patient, donor there shouldn't be any costs associated with signing a consent form.
Perfect. Another question that's come in, are consent forms needed for reciprocal IVF?
Oh, I like this made-up term, reciprocal IVF. I don't know where they found that term. Okay, so if I understand reciprocal IVF correctly, it's where same-sex female couples are doing IVF procedures where the one partner is the genetic mother and the other is going to be the biological birth mother. So the genetic mother is doing an egg retrieval and the biological mother is undergoing an embryo transfer and pregnancy. So I'm not sure why they call it reciprocal, but yes, to answer your question, it would definitely require a very specific consent form. And you see, this is one of these scenarios where we're a same-sex couple and one partner carries her own genetic material, one partner carries the other's genetic material, both partners carry their own genetic material, one partner carries both genetic. It's like the variations are so different that one would need a very specific consent form for each, but definitely one would enter into or sign a consent form.
Yes.
And parental rights and responsibilities of same-sex female couples is another aspect of my practice that we are working on at present, and we are busy waiting on a judgment out of the Pretoria High Court in which we are expecting the provisions of Section 40 to be declared unconstitutional, but there are proposed amendments to make it so that the partner in a same-sex couple automatically gets, but we're not at that stage where the law is as it is, and at present we're of the opinion that it's unconstitutional. In that the non-genetic mother doesn't get parental rights.
I agree. I've actually got some friends of mine who had that issue where they separated. The one partner was a biological mother of a sperm donation baby, and the partner was on the fence as to whether or not she had rights. So it's a very
So we advise a court application before conception to confirm parental rights and responsibilities. So there's no argument between same-sex couples, or there's no dispute, or there's no confusion. Both get put on the birth certificate. Both are given parental rights and responsibilities from the moment of birth. Just same as heterosexual or same-sex male couples under a surrogacy. So no need to adopt after birth or enter into a parental rights agreement. None of that rubbish.
Yeah, no, I agree. How is the child resulting from gamete donation protected? I know we touched on this earlier, but
so it's actually, it's a bizarre, I don't know, I was debating this with a couple earlier the week, late last week, with regards to the identity of a child born through artificial fertilization. So technically our law says that the identity of a child born through artificial fertilization cannot be made known, which almost is impossible because the wording of our act goes, no person shall disclose the identity of any person who donated a gamete or received a gamete or any other matter related to artificial fertilization of gametes or reproduction. And then in the Children's Act, it says that the identity of the child cannot be disclosed. So it's very confusing because if I'm a same-sex male couple and we have a child, how do you do it? What do you do? Do you just immaculate conception just arrived. No gamete donor involved in this process. So look, I mean, obviously the identity of children is, vehemently protected in South African law. But, I don't think one is entitled to run off to the news media and identify a child born from surrogacy and or gamete donation and or identify a gamete donor specifically. So children are protected by our law relating to the protection of children and, the rights of children under our constitution. But it's very confusing in that there's specific prohibitions on making an identity of a person or child known where it's clear from the circumstances that they had to have been. So our law is very confusing, in other words, is what I'm saying.
Yeah. So, I mean, if I was born, let's say now I was born through IVF with a sperm donor, would I not have any rights at a certain age? I know that we touched on this earlier, and I know you said it's in Australia they have rights, and also I know of the UK. But if I wanted to know,
so as so you are entitled to only access the biographical and medical information concerning your genetic parents. So you can only access medical information and any other information concerning your genetic parents, but only once you reach 18.
Okay.
And that information is kind of regulated in terms of our regulations to our National Health Act, and they include physical characteristics, hair color, eye color, height, interests, results of psychological assessment, some genetic screenings that might have been done for the clinic. So specifically, it's age, height, mass, eye color, hair color, complexion, population group, nationality, religion, occupation, highest education qualification, fields of interest, family history, possible genetic conditions, carrier status, or any mental illnesses in the family, or brothers and sisters, and no other identifiable information. But the problem being is that there's no central donor data bank which holds this information. It's recorded at the clinic, and if the clinics haven't got proper consent forms, then there's no information provided, so therefore the child can't access this information. It's a bit of a mess at the moment, to be brutally honest.
Okay, that's
so a child has rights, but whether he or she or they can actually enforce those rights is kind of something that one doesn't really know.
Yeah. Okay, thank you. We've got about 5 questions left, and I'm just going to check if we've got any more coming in. Do both partners sign the consent forms, or just the partner carrying the pregnancy? I think you mentioned that earlier. Both would have to, yes. And I know that you're always working on some interesting cases. Have you worked on any cases recently relating to parental rights, within the fertility treatments?
Well, our most interesting at present is the same-sex female couple application for parental rights and responsibilities to get them to obtain parental rights prior to conception, or at least confirm it. Unfortunately, we haven't been involved in any of these known donor cases where the known sperm donor is trying to access the child or get parental rights and responsibilities. We do advise a lot of couples or partners in the scenario where they are getting divorced or separated, and the wife per se wants to undergo treatment using sperm donation, and a lot of clinics require the consent of the divorced spouse or the separated spouse to confirm that they consent to the treatment and or that they're not a party to the treatment. And it's very difficult if there's a acrimonious separation. So so what happens if my partner won't consent to the process? Your kind of partner, it's assumed in terms of our section 43, if you're using gamete donation, that your partner has consented to the process. If your partner doesn't consent to the use of a gamete donor and there's some kind of record of it, then he or she won't get parental rights and responsibilities.
Okay. So that leads us to the next question. Oh, sorry to interrupt.
No, go for it.
Okay. The next question that comes in, what happens if my partner doesn't consent? I'm not sure in what respect they're referring to, though.
Yeah, so I mean, if you were a couple and you were wanting to undergo treatment, both partners would need to consent. If you were a married couple and now one partner is refusing to consent to treatment where there's genetic embryos in play, then you wouldn't be able to proceed with treatment without that partner's consent. An interesting concept is whether a woman can proceed with treatment using embryos that have been created using donor sperm and her genetic material, as to whether she is entitled to proceed with treatment in the absence of her husband or ex-partner's consent, because he's not genetically linked to the embryos and he's not technically an owner of the embryos in terms of our law. But I think our clinics rightly err on the side of caution and refuse to do treatment until there's some kind of agreement in play. The problem being is that often there's potentially other children already born as a result of those embryos, so it's very confusing as to whether the wife owns the embryos or whether the husband has a say, because then our children involved whom he has parental rights responsibilities over, and if she has another child using the same embryos, they'll be direct genetic linked, but that child doesn't have a father and that child has a father and a mother, but we're brother and sister. It's like stop, go court, see ya.
Yeah, exactly.
Get some confirmation.
I didn't actually realize how complex this whole thing is. It's crazy.
Yeah, it's fascinating.
Yeah, it is. So we've got someone who's sent in a message from Europe. He says, we live in Europe. How will the consent form signed with the South African clinic hold up in our country?
Look, the clinic consent forms signed in South Africa would relate to your treatment in South Africa, specifically for your treatment in South Africa. If you were worried about some form of parental rights and responsibilities in Europe, then obviously one would get advice from a European attorney or fertility specialist as to how your treatment that you've undergone in Europe would impact on some kind of disclosure requirement in Europe. But in reality, the fact that you've done treatment in South Africa and you're now returning to Europe pregnant, I would assume that one doesn't necessarily need to disclose anything to anyone. But your clinical consent form would still apply to your partner because it would be used as evidence as to your guys' intention at the time. If you're worried that there is some issue with parental rights and responsibilities, it'd probably be advisable to get legal advice from an expert in your country of origin.
Yeah. Okay, great. So what is the difference between a consent form and your disposition agreements?
So a consent form is something that's signed with you in the clinic.
Okay.
And it specifically relates to your current or future treatment, and a disposition agreement or declaration for that matter, is a legal document between you and your partner, or you as an individual, in which your intention is recorded.
Okay.
In which instructions are given. So you can think of it like a will, but it's like an advanced life directive. So do not resuscitate, for example. If I'm in a coma and I stop breathing, don't resuscitate me. It's kind of like a DNR and an advanced life directive where it gives instructions. So they're two different documents.
Okay. And the final question, Andrew, must the forms be signed in the presence of our doctor, or can we sign these at home?
Oh, geez, if you want me to answer that in all honesty, I recently opened a new bank account at a bank, and my opinion is that we need to all link ourselves to the Department of Home Affairs' fingerprint system, and we need to sign these documents by putting your fingerprint on these things. You're creating children. I'm sure there are instances where partners have forged signatures of partners and undergone treatment at home. If I was a medical practitioner and I was creating life and I was in communication with one partner specifically, I would definitely want to verify the fact that the other partner has consented. I've even heard of scenarios where the husband is dead and the wife is, or divorced and the wife is forging signatures, or the husband is forging signatures. It goes both ways, obviously. And so, and I think a lot of the fertility clinics, especially South African fertility clinics, struggle because we do a lot of international patients, and a lot of times it's predominantly the wife that travels from Angola, Nigeria, Australia, Europe, wherever, to come and have treatment in South Africa. So I would say that it would be better from a legal liability perspective to have it signed in your presence, or alternatively to have some kind of verification done. So what we've done in our embryo and gamete discard consent forms, where you are instructing the clinic to discard embryos, we get the parties who are internationals to have their signatures commissioned by and certified by a notary and or a commissioner of oath, so that the clinic can verify that you are you who is signing it, and you are duly authorized to give instructions on that consent form. So it's predominantly where the spouse has died and the wife is now, or the husband is now wanting to discard their embryos.
Yes.
We require, death certificate, IDs, the signature of the wife to be verified by a notary, and certified documents, so that we've got conclusive evidence of the circumstances. But yes, I would like these things to be signed in person and or electronically signed through a secure signing portal.
Yes, I agree.
We are South Africa, where people don't have data on their cell phones, so it's difficult.
Yeah, I can understand that. So I'm mindful of time. So any questions that we've missed during the event, Andrew, I'm going to send through to you, and we can answer those personally.
Absolutely.
Or you can answer those personally. And it's been a very informative session. Thank you so much, as always, for joining us.
Pleasure. Thank you for having me.
It's an absolute pleasure. What we're actually going to do is we're going to recreate this link with your contact details on the end of it, and pop it onto our YouTube channel, and people can get hold of you directly through that.
Great. Then I look forward to being contacted or answering any additional questions that listeners or any patients might have.
Excellent. Thank you, Andrew. Have a lovely day. Okay.
Thanks, Angela. Cheers. Bye.
Bye.